Bear with me one second, everyone. We are just about to start CPD certificate, and it would be great if you could all fill out the online feedback at the end of this webinar, so it gives us an idea of how we could make improvements in the future. Firstly, I need to read out the disclaimer. Please treat the contents of this webinar as food for thought, but please don't take any action based on its content unless you have taken legal advice. The speakers here with me today cannot accept responsibility for any errors or inaccuracies, loss or damage, unless we have given you personally specific advice relating to a matter about which you have given us full background details. You must also bear in mind that the contents of this webinar are based on English law, and because it contains archival material, that material is bound to go out of date. The aim of this webinar is so that you can understand what you can do to recover money owed to you or your business as quickly as possible. We will also give you an overview of the High Court enforcement process and how that can assist you with recovering any of that debt. We'll be covering several different parts of kind of credit management, including minimising the risk, internal credit procedures, charging an interest, what to think about before you go legal, the legal options that are available to you, options for enforcing judgments, and also the High Court enforcement recovery route. Over to you.
Thanks, Sarah. So I'm just going to give a little bit of introduction about the area that I'm going to cover. When invoices aren't paid on time, this becomes an issue for businesses because it's all well and good raising a bill and that adds to your revenue, but it's not worth anything unless the bill is actually paid. And essentially, you're financing someone else's business. As business owners, you'll all know that it has an impact on your cash flow as business because your fixed and variable costs still remain to be paid. If it turns into a bad debt, you're not only making a loss in terms of the debt, but also the goods and services provided and the management time that you spent chasing this debt. For that reason, it's very important that you have a proper structure in place to deal with the payment of your invoices. This will ensure an effective approach to debt collection, boost your cash flow and reduce overdue payments turning into bad debt. The key to the process is to have a proper streamlined structure for debt recovery so that unpaid bills are managed as quickly and effectively as possible and don't slip through the net. Generally speaking, what you'll notice is that the longer a bill remains unpaid, the harder it is to recover. So, first and foremost, we're going to look at the things you can do to minimise the risk by doing your homework. When you have a new client, know your client. Who is your client? Are they a limited partnership, a limited company, a partnership, a sole trader or an individual? And when you have your client first and foremost, think about the things you need to consider when assessing the financial credibility of that client. So for example, think about things like what assets do they have? If it's a company, check out company's website for the latest filed accounts. These aren't conclusive of their financial position today, but they're a good indication of the company's financial health. The other thing to look for is how long have they been trading. If they haven't been around for a long time, you might want to consider how much credit you're prepared to extend to them. Make it a policy to get money on account and up front. You can think about having a payment up front, you can think about a deposit payment or payment in stages at fixed times. Sometimes you may find that those that are reluctant to pay an upfront deposit are often the worst payers, and it's better that we find out sooner rather than later. Put a limit on their credit. Let your customers earn their way to flexible credit terms. The reality is you only want to have clients that are good payers, and so the quicker you find this out, the better. Where you're dealing with a company, think about whether it's worth having personal or director guarantees as an option. This is particularly relevant for new clients or where a business has just been set up. There's no harm in getting individuals to guarantee a company's debt. It adds an extra layer of security for you. However, do remember you need to make sure that the guarantees are worth it and the person who's giving you a guarantee they have the means to satisfy any debt. Finally, look at your terms and conditions of your business. Make sure that these identify the payment date, interest, and retention of title clauses. I will deal with that a little bit further on, but these are the headline things that you should think about. When you have a debt that's arisen, chase your debts promptly via emails, calls, and statements. Some people are just slow at dealing with administrative matters, and chasing them allows your debt to be kept at the forefront of their mind. Updating interest in line with your terms and conditions can prompt quick payment. If people know that interest is being accrued and they're having regular statements letting them know what their debt is and how much interest is being added on, you might find your bills get paid quicker. Do remember, you're not an overdraft facility for someone else's business, and by setting the standard about how you expect your money to be paid sets a precedent on how you do business going forward. Sometimes you just need to pick up the phone. Regular calls with a debtor will make you aware of any genuine dispute over the invoice and allow you to resolve issues quicker and reach agreement quicker. Sometimes you can just pick up the phone and it's easier to take a credit card payment over the phone. If there's an issue, you can find out as soon as possible. As I said just a while ago, send up-to-date statements including any interest that's accrued, as this will force people to make payment quickly. If payment isn't forthcoming, explain the steps that you intend to take to recover the debt so that they know before you start any legal proceedings and they know you're serious. Don't make the threat unless you're prepared to see it through. It's also important to keep a log of the steps taken and record telephone conversations in writing. If you have a call with a customer and they've raised something or they've said something like, yeah, no problem, I'll pay it next week, drop them an email, confirm that. This is really important if the matter proceeds to litigation. It's much harder for someone to raise a defence if they haven't raised it before. So, for example, if you send an email acknowledging that they're going to make payment next week, that's an admission of their liability to the debt. 6 months later, if they raise some excuse for not to pay you, the email will be very handy in showing that any defence that's been raised is really a sham. The other thing that you need to ensure is that you are charging interest, and for that you need to look at the terms and conditions of the contract that you have with your customer. Make sure that your terms and conditions include an express clause dealing with interest and non-payment. You have to remember that under common law, there is no implied term that gives you the right to have the payment of interest, and this is why it's really important that it's in your terms and conditions. When it's in your terms and conditions, it forms part of your contractual arrangement with your client, and courts can't really, as a general rule, increase or reduce contractual interest. Your contract term can also allow for compound interest, which means that the interest is compounded as opposed to simple interest where matters proceed to court. Courts are allowed to award compound interest, but this is really rare. So if it's in your terms and conditions, it protects you better. You may also want to think about having a higher rate than what's implied by law, although do remember that if your interest rates are too high, courts can consider it a penalty and be unenforceable. The other advantage of having an interest clause is that it gives you negotiating power to waive it on dispute sums. So, for example, if a bill isn't paid on time and you're sending a statement and it's showing that interest is accumulating, if some kind of dispute arises, you do have the ability to say, well, actually, I'll waive the interest if you pay the principal sum due to me. So it's a good negotiating tool. The other thing that you may want to think about is incorporating a retention of title clause in your terms and conditions. This is basically a provision in a contract for sale of goods, which means that you as the seller retain legal ownership of the goods until payment's been made. It's good practice to ensure that the buyer signs the terms agreeing to this, and that means if something goes wrong with your buyer, for example, they go into insolvency, instead of ranking as an unsecured creditor, you'll be able to reclaim those goods supplied, and of course that's assuming it's still in their possession, but it means that you can just take your goods back and title to those goods hasn't actually passed. If you don't deal with interest in your terms and conditions, you have limited statutory rights, and therefore it's very important you think about having interest provisions in your terms and conditions. When you draft your interest clauses, think about the following things that you may want to include. Spell out the duty to pay and how this arises. Clarify the interest rate. If it's too high, it will be considered by the court to be a penalty and therefore unenforceable. Just to give you a couple of examples, I've seen agreements where they provided for interest at 5% per week. That comes to 260% per annum, and that has been held to be unenforceable. But something like 15% a year is considered reasonable and is enforceable. When you consider how you're charging interest, are you charging annually, or would you prefer daily, weekly, monthly, quarterly? Do you want simple interest or compound interest? What is your start date for the interest? Is it automatic or on demand? What's the end date for interest? Normally, this is when you are finally paid the monies that are due to you. Do bear in mind that interest only runs in the default period, and you need to give thought to whether provision for interest should be provided for disputed sums. You also need to clarify in your terms and conditions about charging interest before and after judgment should the matter proceed to litigation. In the absence of clear wording in your terms, interest only runs up to judgment, and if the interest rate you are going to charge your clients is greater than the statutory interest rate, you may want to make provision in your terms and conditions that that's the interest rate that applies after judgment. The other point that I want to make, which I haven't put in the slide, is the effective part payment. If someone makes a partial payment, do we want to allocate that to interest first or the principal sum due? Because that's going to have an impact on the overall amount that you're going to claim. Where you fail to have an interest clause in your terms and conditions, all isn't lost. There are certain statutory rights for individuals which you can deal with, but this is obviously only if the matter proceeds to litigation. So the court has a discretion toward interest on late payments, but it's a discretion. So a court may take a view that for whatever reason you're not entitled to interest, and this is another reason why you should make provision for it in your terms and conditions. Once you have a judgment, there is an automatic right to 8% per annum for simple interest. Where you're dealing with a business and your contract is silent on interest, you can rely on the Late Payment of Commercial Debt Interest Act 1998. This provides for implied terms for interest, a fixed sum and cost in business-to-business contracts for the supply of goods and services. It doesn't apply to consumer credit agreements. At the moment, the interest rate is 8% plus the Bank of England's base rate, either from the date of the agreed payment date or where there's no agreed payment date. I've put 30 days after latest delivery of the invoice, but this is the simplistic approach, and the rules vary depending on who the debtor is and individual circumstances of the sale. It can be as little as from 30 days and go right up to 90 days. You can also claim a fixed sum of between £40 to £100 depending on the value of the invoice and any reasonable costs of recovery, for example, debt collection agency fees, solicitor's costs for a letter and pre-action legal costs and internal administration costs. If you do end up having to go legal, there's various things that you need to think about before you issue court proceedings. First and foremost, have you exhausted your internal credit control process? You don't want to launch into litigation prematurely. It can be a long and drawn out process, and sometimes it can be, as I said, just picking up the phone and getting someone to make a credit card payment over the phone. Think about negotiating a settlement. Sometimes prompt payment discounts are worth offering. So, for example, if you send an invoice, you may offer 10% if they pay within 7 days of today. That can encourage businesses to pay sooner, and that assists your cash flow. Think about the value of the debt. Consider writing it off. You need to be aware that if a claim is under £10,000, it's considered to be a small claim, and legal costs are generally not recoverable. You need to weigh up the management time involved in recovering a debt against the sum that you're seeking to recover. you also need to bear in mind that when you bring enforcement proceedings, you don't recover every penny that you outlay, and if you are ever awarded costs, they're subject to assessment, which means that you tend to recover 60 to 70% of your outlay, although the courts apply a proportionality test, and you could recover less or more. Think about what assets your client has that you can enforce a judgment against. There's little point in going after someone who's broke. You'll be throwing good money after bad. Finally, you need to ensure that you've drafted a pre-action letter in line with pre-action protocol. There's protocol that needs to be followed if you go for debt recovery. If you instruct solicitors, they'll deal with this. But if you're dealing with it yourself, search pre-action protocol on the Justice website and review the practice direction for pre-action conduct and protocol, which tells you the duties that you have and the things that you need to include in the letter of claim. If you don't follow this, you can be penalised by the court on costs. So it's really important you comply with this. In terms of possible legal options going forward, you can serve a statutory demand. For individuals, this would be leading up to a bankruptcy petition, and for companies, this would be a winding up petition. A statutory demand is a demand for payment within 28 days. The debtor has to either has to pay within 21 days or apply to the court to set it aside within 18 days, failing which you can either issue a bankruptcy petition if it's an individual or a winding up petition against the company. The minimum debt figures for an individual is £5,000 and for company £750. You should only use this process if there's no dispute that the debt is payable. If there's any kind of defence or counterclaim to the debt, the application will be unsuccessful and you don't want to be in a position where you end up paying your debtor's costs. However, if there's no doubt that the debt is due to you, this is a quicker procedure than using the court procedure and can give you a judgment very quickly. The court fees are steep though. For individuals, it's just over £1,000, excluding solicitors' costs, and for companies, you're just shy of £2,000, excluding solicitors' costs. So, although it's a much quicker option, it can potentially be quite expensive. The other alternative is to issue court proceedings. And once you've issued court proceedings, the debtor can either admit the payment due, in which case you'll get judgment for the amount you're claiming plus fixed costs, or they'll file a defence. If the defence is some kind of a sham, you may wish to take advice on making an application for summary judgment or applying to strike out a claim. Summary judgment is where you make an application to say that the defendant has no real prospects of succeeding or defending a claim, and there's no compelling reason why the judge shouldn't dispose of matters now, as opposed to waiting for when matters go to trial. The other alternative that I just referred to is a strikeout, where a defence is filed and it is your position that the defence discloses no reasonable grounds for defending the claim. It's an abuse of the court's process, and it's unlike to take this matter all the way to trial is otherwise likely to obstruct the just disposal of proceedings. Where you apply for either of those options, a defence can be fully or partially struck out, and judgment can be entered straight away, and you can get on with enforcement proceedings. If, on the other hand, there is a weighty defence that's been filed, the court's going to give directions for the management of the claim, which means that they'll give directions for the exchange of documentary evidence, witness statements, and then ultimately listing this matter for a trial. And that process can take 12 months or so. If matters do get to court, cases are generally listed in what are called, they're allocated to tracks. So you have the small claims track, which are for debts less than £10,000. As I mentioned earlier, costs are only recoverable in exceptional circumstances. You can recover your disbursements like court fees, but generally you will not get legal costs. So the system is designed to encourage people to act in person, but and not to instruct solicitors. If you have a claim that's between £10,000 and £25,000, it's allocated to the fast track. Essentially, these are cases that are quite low in value and shouldn't take more than a day to hear. There's fixed costs for the final hearing, and although if you win, you'll recover your costs, but these are subject to assessment by the court. In practice, a winning party tends to recover 60 to 70% of their outlay in terms of costs, and so you need to work out the difference of what you will actually recover against what you will expend, and factor in this shortfall when you're negotiating with your customer. It may be worth giving them a short-term discount, knowing that ultimately you're not going to recover every penny you spend in legal costs. If you've got a claim over £25,000, this will be allocated to multi-track, and costs are subject to a process called cost budgeting, where parties file budgets of what they believe their costs will be, and the judge is likely to put this down to a limited sum that you can recover from the other side. Again, we come back to the same principle as in fast track. You won't recover every single penny you outlay, and so it's a good idea to factor this in when you're trying to negotiate payment of a debt. When you get to trial, you need to consider, does a win at court guarantee payment? The short answer is no. When you win a case, you're awarded a judgment, and normally the time for paying is 14 days. If the defendant doesn't pay out by the time limit given by the court, you then have to take steps to enforce that judgment. There are a few methods available, but this involves additional fees, both in terms of court fees and solicitors' costs, and these methods do not guarantee payment. It's therefore really important that it is crucial to understand your customer's ability to pay when you start to trade with them and before you begin court action. The other thing to remember is that when you do have a judgment, interest runs not only on the judgment itself, but any costs that are awarded to you. Once you have your judgment, you need to consider the most appropriate action having regard to the debtor's assets. And this is why it's important right at the beginning to know your clients, know what assets they have, so that you can take the appropriate action. I've highlighted a few options that these are not conclusive, but they are popular options, which is why I've raised them. Third-party debt order. This is a third-party debt order is a method of enforcement of a money judgment. By third-party debt orders, sums owed to a judgment debt that are in the hands of a third party, for example, a bank, are frozen and seized for the benefit of a judgment creditor. So you could get an order freezing money in a bank account held by someone. Sometimes you get a windfall if that person has a lot of money or that business has a lot of money in their bank account, but sometimes you get nothing. And so the timing of this is really important, and you may want to think about serving these types of orders on payday when you know that a debtor is coming into money. Secondly, you can go for an attachment of earnings order. This is a method of enforcing a money judgment in court proceedings and provides that judgment of a debtor's earnings be deducted by their employer and be paid straight to you. The rules around an attachment of earnings order are complex. The debtor's obviously got to have some money to live on, but what it does do is that it takes away you chasing the debtor, and it ensures that an employer takes money directly from a debtor's salary and pays that to you. As I mentioned a few moments ago, the options of bankruptcy and winding up proceedings are still there, and although I've talked a little bit about the circumstances under which you use them, you need to be aware that making someone bankrupt or winding up a company is quite a hostile act, and you need to weigh up whether this course of action will get you your money or simply put an individual or a business into either bankruptcy or liquidation. Consider your objective. Is it better to agree an instalment plan and get your money, or put your debtor out of business? Finally, you can think about a warrant or writ of control. This is about repossessing the debtor's assets. As a judgment creditor, you can obtain a writ of control from the High Court and enforce the money judgment. A judgment creditor takes control through a bailiff, takes the debtor's goods and sells them, keeping the proceeds of sale to discharge the debt. I'm going to now pass on to Matt, who can deal with that process a little bit more from his angle. But just to summarise, before you get to litigation, know who you are dealing with and act appropriately. It's better to be safe than sorry. So the more you know your clients, the more you know about them, the better for you. Have in place a proper structure for credit control and ensure the steps you take are properly recorded. Send a letter of action promptly, and before you go to take a more formal and legal step, consider whether your customer has the ability to pay the debt and what steps you'll be able to take to enforce the judgment.
Okay, thank you very much for that. Very useful advice there. I'm going to launch a couple of poll questions on the content that was just covered. So that question should be up on your screen now. How much interest can be added to a judgment debt? I'll give you a couple of moments to answer that, but it looks like we have a clear winning answer, which is 8%, and that's right, the correct answer. Yeah. Thank you. Let me just launch the next question for you guys. And that question is, if the debt owed to you is $15,000, which court would you be using? And the correct answer there is the fast track. And the final poll question, which has just been launched, what options are available to you if you have a judgment but still haven't been paid? And of course the answer to that is you have all those options available to you. It's just a case of deciding which one is best for the circumstances. Lovely, thank you. I'd like to hand over to Matt now. Bear with me one. There we go.
Thank you ever so much. Thank you, Sangeeta. Some really great ideas and food for thought, clearly showing your expertise. And you've brought us up to a point now where you've got your CCJ, you've got your county court judgment, which is effectively a bit of paper that says what you're entitled to. And you've still got to go through the enforcement process somehow with the options that you've already seen to try and recover that money. Yes, it does leave a black mark upon their credit file, but you've taken the due diligence to get this far. You're actually going to try and recover the money. What we're going to do is have a little look in a bit more detail at the High Court enforcement process via a High Court writ of control. So a little bit about a High Court enforcement company. You've got to have a HCEO, a High Court enforcement officer, who's authorised by the Minister of Justice, appointed by the High Court, and they must be present within the company in order to operate as a High Court enforcement company. There are authorised enforcement agents that are licensed that work underneath the badge of the authorised officer that actually go out, feet on the ground and knock on the doors. So the jurisdiction covers England and Wales. If you've got a debt across borders, typically Scotland, you can still get in touch with us because we've got partners up there where the law is slightly different and sheriff means something else. But for High Court enforcement in this country, our authority is England and Wales. So you transfer up your county court judgment to a High Court writ of control. And as explained, the writ of control gives you the power to take control of goods and assets, tangible assets, that can, not necessarily will be, but can be sold at auction to clear the funds owed on the satisfy the debt on the judgment. Very important, the CCJ has to be £600 or over, and it has to be within the last 6 years. It's a statute of limitations. There are certain circumstances where you can ask for an extension on a county court judgment for another 6 years, but you would have to prove to the judge and courts what you've done within that first 6 years to try and recover the money. And if nothing's been done, it's unlikely to be extended. Any judgments under 600 would have to be enforced via a warrant of control in the county court bailiff system. Any judgments over £5,000 have to be enforced via the High Court. So you've got a bit of middle ground there between 600 and 5,000 where you've got a choice. You could go county court bailiff or High Court. High Court have got a better success rate, and that's what we'll go into a little bit more detail, how to get your High Court writ of control. So not just county court judgments. If your judgment or order was actually made in the High Court initially, you can transfer across to a High Court writ of control. We also look at employment tribunals, whether they're ACAS or otherwise, and they can be transferred up to a High Court writ of control. Possession orders, whether that be possession of land or property, can be transferred up to writs of possession, which is a different webinar, so keep your eyes peeled for that if that's of interest. And there's something called a writ of delivery, which is recovery of specific goods or items that would be named on the writ, which doesn't crop up that often, to be fair, but we can enforce those. Very important, if you've done your homework and got the judgment correct in the first instance, then the writ will be correct. The writ mirrors the judgment. So the information such as debtor's name being spelled correctly, being in the right order. If you got it wrong on the judgment, it would be wrong on the writ and unenforceable. Suing the correct entity, you again will have taken that decision of who to sue on your judgment. But if it's a self-employed or sole trader, it's good to have both names of both the individual and their business trading name, because we're looking for assets, and if both names appear on the writ, judgment and writ, we go up the individual for assets in their name, but also any assets within the company name. We rely on you to provide the enforcement address. We need somewhere to go. We can go to multiple addresses, but you do need to supply the address. So if it's an individual, a current home address. If it's a business, their current trading address or addresses. Quite often we'll be supplied with a registered address, which is an accountant, where we're not going to be able to enforce the writ, most likely, and we'll be looking for another address. Sue for the correct amount owed. It seems obvious, but it's always worth double checking that you've got your figures right. What we're trying to do is just negate any opportunity for the defendant to have a case to apply to the court to set aside the judgment, to delay the whole process. You will have checked for insolvency proceedings, I'm sure, prior to enforcing and sending it to a High Court enforcement company to transfer up. We also make those checks as well, but to not waste time, it's worth checking the bankruptcy register and Companies House. Obtaining the writ is made pretty straightforward and easy for you. You can do it yourself with court forms, but why would you when the High Court enforcement company, on the strength of you providing a copy of the judgment and the particulars of the case, which often will be put in a simple instruction form, is enough authority then for the High Court enforcement company to do that work for you, and they shouldn't charge you for it. So the transfer up process is on the next slide, and I'll run you through it quickly, but all you need is your copy of the judgment, an instruction form, and the £66 court fee. It's actually called an N293A. The form, Part 1 and Part 3 are filled out. That enables us to get Part 2 sealed. Once Part 2 is sealed, then we can apply for the sealed writ of control. It varies how long it takes. We alluded to an employment tribunal, which will take probably about 28 days. A standard CCJ transferring up to a writ of control should only take between 5 to 10 working days. It depends on the court. It depends how busy they are, how efficient they are, the time of year, how well staffed they are, all of the above. And I'll just run through the process that's not on the slide here at this point of what happens then once a sealed writ of control has been obtained. The first part of enforcement is what's called a notice of enforcement. It's a 7-day payment letter that we have to send by regulation. We have to allow for postal grace. We can't include Sundays and bank holidays. So that letter will go out, and over somewhere like Christmas or Easter, it could be a 12, 13, 14-day period. During that period, the defendant has got the option to pay in full, otherwise we shall attend. Invariably, they won't pay in full, and we shall attend. So once the expiry has become of the notice of enforcement, the case will be allocated to an enforcement agent for attendance. They should attend within 5 working days, and then a report upon their attendance will be turned around and sent back to you, our client, again within another 5 working days. So, what's the outlay for you? The £66 court fee is all you've got to pay to get the ball rolling. It's added to the debt, so if we're successful, you get it back, and it's actually the only fee you would pay for us to go out and start the enforcement process. The only other fee you need to be aware of is if we are unsuccessful for whatever reason, whether it be that the debtor has skipped, we cannot trace them, that it's the blood out of a stone scenario, they've got absolutely no assets, no means to pay, whatever reason, and we don't collect a penny and we have to close the case, the fee that we have to charge you then is the £75 plus VAT. It's called a compliance fee. The Tribunal Courts Enforcement Act determines that we have to charge that. We don't survive by charging compliance fees. We don't want to charge compliance fees. We want to be successful. But it gives you an idea of the risk outlay you have to consider for High Court enforcement for transferring up a CCJ. It's £156 potentially, your court fee and a potential compliance fee at the back end. I'll put in at this point, our fee is made in addition to your judgment. So if we are successful, you get the full judgment amount, plus your £66, plus any interest, which we've mentioned interest, from judgment stage, if your judgment's over £5,000, you get interest at 8% per annum, calculated and applied daily, which isn't a bad savings rate to have. If it's under £5,000, it's 8% from the date of the writ. Solicitors, if there's any solicitors logged in, also are eligible for a £51.75 admin fee to be added onto that. And our fee is in addition to your judgment debt. That's how we make our money. It's regulated by the Ministry of Justice. It's set in stone what we can charge and at what stage. And if anybody would like our guide to enforcement after this webinar, it's detailed within there what that fee structure is. We have to hold any monies collected as per the Insolvency Act, just in case there's a winding up order or bankruptcy petition. Okay, so to dispel any myths, preconceptions, we cannot force entry into residential premises. That's it. We can only enter through an open door or be invited in. It doesn't mean that we can't try door handles. We can go around the back and try back doors. Summer is a great time because doors are open. Used to be able to enter through an open window, but as of 2014, we can no longer do that. Not that many of the enforcement agents could fit through an open window. We cannot enforce at diplomatic residences. So consulates, embassies, royal residence, the writ is not authorised to be enforced in places like that. We can force entry, however, on outbuildings at a residential premises, as long as it's not connected to the main building, if we believe there are assets in there. We can force entry into commercial premises. We don't have to that often because we've got the power to. You'll quite often find the company owner, director will come down and open the locks instead of us having to break the locks. From From that point on, it's all about what assets we can find. If we have got inside to a residential premises through an open door being invited in, we do actually have the authority to break internal doors down, again, only if we've got a strong belief there are assets behind that door. It is a criminal offence to obstruct a High Court enforcement officer with the enforcement of a writ. We can call on the police, who have to back up the enforcement officer carrying out their job. So the power of the writ, as I've said, is to have the ability to take control of assets, seize assets to the value of, and remove and sell those at auction if necessary. However, should there be sufficient assets, what we would do in a normal scenario is put those on a controlled goods agreement. It's signed by a responsible adult or the defendant, and once goods are on a controlled goods agreement, it's illegal to remove or sell them. They are the property of the court, and there could be a criminal case to answer for if goods on a controlled goods agreement or a CGA are removed or sold. Nine times out of 10 with an individual, we are looking at a car, a vehicle. As soon as we've been instructed to transfer up a CCJ to a High Court writ of control, we can actually check with the DVLA if we've got a number plate, whether they are the registered keeper of the vehicle or not. As soon as we're out knocking on the door, we're looking for vehicles in the vicinity, we can run the checks, and if we find one registered, it's all about using that as our leverage to get some kind of payment. But it's not just cars. We have seized boats, aeroplanes we've taken control of on the tarmac, bigger pieces of machinery like printing presses, farm machinery have been taken control of, not necessarily moved, because it is our leverage to then elicit payment. Jewellery, art, money. Less common, things like bonds and shares, jointly owned property. If the debt's in the name of a husband, we go to the house, there's assets there that are partly owned by the husband but also the wife. They are eligible for enforcement, and we can take control of those. Goods on finance, it could be that the vehicle is a high value vehicle, it's on finance, but if we contacted the finance company and we find that they're behind on their finance payments, it's not unheard of for the finance company to agree for the goods to be seized and sold at auction as long as it holds enough value. As you'd expect, things that can't be taken, white goods, soft bedding, items belonging to vulnerable people or children, children's toys. One to just focus on if you're looking at a sole trader, self-employed, is tools of the trade. We have to leave enough value up to £1,350 so that they can continue with their work. Again, with a vehicle, we have taken a works vehicle and written a cheque for £1,350 and left it with them if it held enough money to actually pay the debt, allow us to leave that money once sold at auction. So it's not that we can't take it, but yeah, there's some obviously perishable goods, items that are going to go off that we can't store, and they're going to be worthless. So the attending officer must take control of the goods. As I said, if the debtor's not around, the responsible adult can take control and sign the controlled goods agreement. It is illegal to remove or sell those goods. If they are sold, not only could it be a criminal matter, but we can go and seize those from the unfortunate individual who may have purchased them. Where wouldn't go down the controlled goods agreement route, but there are assets there, and we actually end up removing those assets, more likely to be because we believe they're at high risk of disappearance. It might be high value goods, antiques, jewellery, something like that that are quick to remove, and perhaps the defendant is making it clear that they intend on moving them. They're not going to sign the controlled goods agreement. They're refusing to deal with the enforcement agent at the time. then we will go straight down the route to sale and removal and take those goods away to be sold at auction. It might be that they were on a controlled goods agreement and there was a payment plan in place, but that payment plan has defaulted. We can then, if it's a residential property, we can actually use force of entry to go back in to recover those goods and sell at auction. If it's a company, yeah, we would just go in anyway and we would remove those goods because they're on a controlled goods agreement and the instalment plan was defaulted. So the goods remain seized until the debt's paid in full. We can return for further items if necessary. There was one unfortunate defendant where we did remove a car, sell it at auction, and we went back 6 months later, they'd replaced their car, and we'd actually removed that to satisfy the remainder of the debt. So they lost 2 cars. The life of the writ typically is 12 months. If there's an instalment plan being adhered to and then it breaks, we can actually reset that 12 months so a writ can continue on beyond 12 months. We can use all types of auction. We would have to give 7 days clear notice that their goods are being sold at auction, but public auction, we do use eBay for the bigger items such as farm machinery, equipment, printing presses. We can do an on-site auction. We don't actually have to move the goods themselves. And there could be a private contract with the permission of the court if we've got specialist equipment and we've got a buyer that's been recommended who would probably buy them for a better price than if they were in a normal auction. That's been done before. We would be checking for wind-up orders or bankruptcy petitions because if an item had sold at auction, monies had been realised, been kept for the 14 days, and then it turns out that actually they were the defendant was party to bankruptcy or winding up, then those monies would have to be returned to pay all the creditors. Sometimes goods are seized where there's a query as to ownership. It's now called CPR Part 85, the Civil Procedure Rule, Part 85. It used to be known as interpleader. It's third-party claims to goods seized. There is a set process that has to be adhered to under CPR 85 as to how to go about laying claim to those goods being your own. It must be made within 7 days. The third party has claimed ownership of these seized goods, or the debtor claims that the goods are exempt from seizure because they're owned by a third party. The claim goes to the creditor or the claimant, and they would have to admit or dispute the claim within 3 days of being notified. If it's disputed, the rest of CPR is detailed online, and you can have a look at that. But basically, it would end up in the courts in front of a judge with all evidence gathered, and it's down to them to decide final ownership of those goods. And depending on the outcome, will depend whether we have to return those or that they could be sold at auction as per the initial enforcement. Just to summarise then, High Court enforcement via a writ control, CCJ has to be 600 or over in the last 6 years. It's a quick, low-cost way of trying to recover that unpaid judgment debt. Thank you.
Okay, wonderful. I'm going to have a quick learning review, but we've had lots of questions in. If we don't get an opportunity to answer those today, we will be circulating via our newsletter that you should all be signed up for, a webinar Q&A. So we will be answering all your questions via that. So bear with me 1 second while I just launch the next set of poll questions, which are the final set of polls. So please do answer them. Thank you. Perfect. So it looks like most of you got that question right. The answer was £600 is the minimum value for a transfer up to the High Court. And it looks like most people have got that one correct as well, so I will close that poll, and the correct answer was £75. And that was the compliance fee for an unsuccessful...
Plus VAT.
plus VAT. And the final poll question is just about to be launched. Which of the following goods cannot be seized? And yes, it looks like most of you, or all of you in fact, no, most of you, perishable goods. We cannot take perishable goods because they will perish. Okay, let's have a look at some of the questions that have been coming in and see if we can answer one or two of them for you. There's a good question here. Number one, are you a government agency?
No. Authorised and appointed by the High Court, the authorised officer. And you've got to have the authorised officer as part of your company structure to operate. But no, we're a private limited company.
And another question for you, Matt, by the looks of it. If a name is spelt incorrectly on the writ, does that mean it is unenforceable?
If it's spelled incorrectly on the judgment, you would need to go back to the issuing court. There's something called the slip rule, if it's just a slight mistake, and get that amended. If it's correct on and then we transfer it up again. If it's correct on the judgment and it's incorrect on the writ, we can return to court under the slip rule and get that corrected, and there's no cost to that, and it happens pretty quickly.
Okay, thank you, Matt. I think what we'll do is we will answer the rest of the questions that have come in, because there are quite a few of them, as I said, on the newsletter articles that we will be circulating in the next couple of weeks. So hopefully you are all signed up to those, so you will receive those answers. And if you do have any other questions, I will be ensuring that you have the slides, the recording, the CPD certificate, along with the details of both of the presenters here today who have been very informative on that email that should be with you in the next 48 hours. We will send that out, so if you don't receive that, then do let us know. Thank you very much for your interest in this webinar, and we will be holding the next one, which I believe is in November, and that will be covering residential evictions and the process for that. Thank you very much again.